what's up, y'all? I'm Jay Julio Vela here for Harris County Criminal Lawyers Association Reasonable Doubt. Along as always is Justin Harris. How are you, man?
Good, man. I'm not happy to have this
Also on
pimple.
the news,
It just came up from nowhere.
I can see it from here.
Yeah, everybody can see it.
No, dude.
Turn on the light, and there it is.
Past President, lawyer extraordinaire Todd DuPont. How are you, sir?
Hey, brothers. I'm good.
Lawyer extraordinaire Wade Smith. How are you, man?
Hey, JV, I'm doing good, man. Good to be back on here.
Jamel, how are you, man? Jamal, how are you, man?
I'm
Jamal,
fantastic,
how are you,
JV.
man?
I'm great.
Dude, look, Jamal and I have been friends for like a decade, and I just love you, dude. You're freaking awesome. Remember the time when we had the same individual, and we got it both of his cases? You were on the felony, I was on the misdemeanor, and then we ended up getting both of his cases dismissed. You remember him?
Absolutely remember him. I was talking about him the other day and how horrible some of the court appointment policies were when lawyers refused to go to trial, and how some lawyers just let them get off the case because a client won't take the deal and they don't want to go to trial.
Really?
Yes, I remember. 100%. David Ryan came in on the play. He came in on the move. Hey, David, how are you? David Michael Ryan.
How are all of you?
How are you? David's running for secretary. Good luck. HCLA board member. If you're a part of the HCLA board, vote. We have elections that are coming up and that are outstanding and ready. Todd's a past president. Justin, are you running again?
I'm running unopposed for treasurer.
Oh,
You're running for board. Wade's
I'm
running
running
for
again for board. I am.
Yeah,
Wade,
Wade
are
and
you
Jamal
running?
are both running for the board, I believe. Or no, Jamal's on the
Jamal's
board.
on,
not
Jamal's
up
on the board.
Yeah.
Yes, but yeah, I am running. I'm looking forward.
So it's looking to
John
me like
Fowers
the
is on.
bearded guy was protected in his seat. That's what this is about. It's discrimination against those of us that don't have full beards. That's what it is.
Two people just came on. Sean Powers, the master of intake. How are you doing, man?
Very well, very well. How are you, sir?
Good,
Very
Sean,
good,
I'm
very
glad
good.
to see you're appropriately prepared.
Well, I think it'd be inappropriate if I brought the handle out. I think it'd be inappropriate. I kid. Past president, lawyer extraordinaire, not guilty master, Mr. Robert Fickman. Past president, how are you doing, sir?
All right, how are you, JV?
I'm very good. Hey, look, we have two past presidents on the show today.
Hey,
Todd DuPont and Mr. Robert Fickman. You know, I on Rob. You know, this is just me spitballing.
Looks like Hollywood Squares on my TV.
No, it's true. But I remember. So
And interesting that it's the youngest guy in the middle square.
Yeah.
hey, he had a story. No, Todd, I remember us sitting chatting with Todd, and he would talk about when he was president. It would always be like, "What would Rob Fickman do?"
Was that about 3:30 this afternoon? This conversation?
No, this is when Todd was president. Remember when Todd was president? I will tell you.
It was
Do we have electricity
8 years ago.
How long ago?
2014.
That's incredible. I remember Rob. Todd would sit around and worry, and me too. Worry that he would continue to carry the torch that you
did a great
ignite.
job as president. Todd was a fine president. We've had a lot of good presidents, but Todd was a great president, and it not bore the viewers at home, all three of them, but there was one time during Todd's presidency where he just about belted me, and for good cause. But Todd was president, and also, I mean, this show. How long were you the host, Todd?
8 years.
I mean, this is amazing. You're not in a mental institution, but
I remember
I was the host before Todd. I was the host.
There's
before
this
Todd.
story about how you played. There's a story that goes about. I've never seen it, but there's a story that goes about how you played the thing, the football, the flick football, because you
Oh,
called
yeah.
out whoever was
Well,
the sitting district attorney or something. I
no,
dare
it was
you
the
to call
governor.
in.
Basically, the governor had
Rob, we can't hear you.
Can
I
you
need
hear
you
me
to
now?
speak closer to your mic.
Todd, did you really have to tell him that?
Yes,
Can you hear me
because I
now?
want to hear what he has to say.
All right. Well, can you hear me now?
Yeah.
All right. Kevin Fine was the co-host at the time, and we were mocking the governor. So we said, okay, we're going to give live open air to the governor. Has 5 minutes to call in to deny these allegations, and can't remember what they were exactly. So then during that 5 minutes, we played the football thing, and I'm sure that's fascinated to everybody. Okay, I'm about done.
And then the governor called in, right?
Wade has a lot more important things to talk about. So
I will tell you that the backbone of Reasonable Doubt to the last 20 years has been the members and the community, but always it's Mark Pirtle down at Houston Media Source. How you doing, man?
Yeah, for sure.
Thank you. Thank y'all for producing.
no, Mark
question.
also shot some.
HCLA has awarded him,
Yeah,
and we probably should award him again. But
Hey, he just ran out. Time for Rob and I to drop all the F-bombs.
The FCC still watching.
there's been a few.
He probably
Hey,
went
well,
to get, hopefully went to go get his award so we can see.
He's only
what
got so
people
many
out there may
hands.
be winning.
We could go crazy on him.
We interviewed people who told stories.
There it is.
Rob, speak closer to your mic, bro.
One of the stories was, well, what's wrong with this courthouse? That was, I think, the first one we did, or the second one, and everybody had something to say about what's wrong with the courthouse. You know, amazing. They're not exactly identical to the problems of today, but why don't I shut up so Wade can talk about what he's experienced? Because Wade and Jamal.
We've got a
Sure.
lot to talk about. So much has happened since we were last on. We've lost post members of HCCLA. We've lost members of the Public Defender's Office who were instrumental in getting people services they needed. We saw a resolution to the George Floyd killing, Derek Chauvin trial, and unfortunately more killings at the hands of police by young black men. We have a lot to cover this tonight. Everybody's been kind of corralled and agreed to come on to kind of help us address a lot of different issues that are going on.
Who's watched the George Floyd trial, right, the guilty verdict? So there was 3. I don't understand how he was convicted on 3 separate charges for the same. It's not. Well, I guess it wasn't the same offense. Can somebody explain that and help me understand that?
Minnesota law, to be a true lesser included, all the elements have to be the same. In each one of these, the elements were different. So therefore, he could be convicted of multiple counts. Now, it's still only one judgment. Okay, he doesn't get multiple punishments for it because it all arises out of the same transaction. But they were able to charge him under multiple theories for him to get the sentence that he will eventually get. And I think, Justin, at this point, we can call the George Floyd situation no longer a killing, but a murder, since a jury of his peers has so found beyond a reasonable doubt.
That's true.
Did the defense just
One was unintentional murder and one was manslaughter.
Right. Remember, in other states, they have involuntary manslaughter and voluntary manslaughter. The Texas equivalent is sudden passion and manslaughter.
Okay.
David, do you know how much time he can get?
It's suggested at the moment, I believe it's 12 and a half, and then there can be some upward departures for aggravating circumstances that could take it to as much as 45 years.
Well, the upward charge yields a 40-year sentence, but in that state, they do guidelines like the federal courts do. So.
Well, my understanding was that the second degree murder charge that he was convicted of, which was the most severe, had a punishment range of up to 40. And
Correct.
third degree murder charge that he was convicted of had a maximum of up to 25. And then the manslaughter charge was like 4 or something like that.
Right. Right. My understanding is that there's a base that starts at about 12 and a half, somewhere around there. And then the aggravating factors can take it up or down from there. And that's actually, probably a place where we could talk, not to take over the show on you guys, about what's still coming. For those of us that do criminal defense, we're used to Apprendi being aggravating factors being dealt with at guilt innocence. And in Minnesota, apparently that's not the way it goes. You can either have the judge or the jury then determining the aggravating factors, and they've opted to go to the judge. That might have been a tactical mistake by the defense. I'm talking about for appellate issues, not for sentencing. For actual sentencing, it's probably the right decision. But with all of the stuff that's gone on outside the courthouse and the judge actually commenting on it, there might have been some appellate issues that would arise by having the jury handle that.
In Minnesota, it's court punishment, and they
Right,
have.
but the aggravating factors can be determined either by the judge or the jury, and he opted to go to the judge. I think with politicians popping off while no verdict had been rendered yet, with or some groups out there not only violently protesting, but then in the immediate aftermath taking credit that they would have harmed the jury, but for them finding him guilty on all charges. I think an appellate point may be lost at this point.
Well,
Did the defense drop the ball? I mean, because there was a whole lot of criticism about the defense. Number one, did he ever have a chance? And number two, from what you all have seen, what are some pro tips that
I got to be honest with you. I'm loath to criticize another defense lawyer's conduct of a case when A, I don't have access to all the information, and B, I know both Rob and I can address this. You younger and Todd, you younger pups, maybe not so much. But sometimes when you are doing the thankless work of defending the most hated person in the courthouse, there are no good choices. You just do the best you can with what you've got. The old saw is when you have the facts, you pound the facts. When you have the law, you pound the law. When you have neither, you pound the table. This defense lawyer made his strategic decisions. I am sure a writ lawyer will be taking it up at some point in the future, and that's probably be an appropriate time to question his trial strategies, but I'm not prepared to do that tonight.
I wonder if the defense counsel had the opportunity to sever the accusations, or they were all tried all together, and if that caused an issue. I mean, that's just my thought.
well, I mean,
I know.
why would he sever
88
it?
Sean Powers goes in.
Why sever it and give them 3 different bites at the apple? I would just say, and I would like to hear from Wade and Jamal and Sean. I think I agree with what David said. I mean, I think that we could sit back here and criticize this lawyer, but I think overall he conducted himself with dignity. And I mean, his client murdered a man in broad daylight and was videotaped doing it. So I mean, he needed to be convicted for murder. That's my opinion. I think the lawyer did it about as good as he could. I'm sure there was a lot of tactical stuff that better lawyers would have done a better job at, but they couldn't change the ultimate fact, which was this man was videotaped murdering the man. That's what I think.
I wonder if there was support from when we looked at the Casey Anthony cases and such, there was money behind that because it was, from what I understand, he got funded by private individuals or corporations. I wonder if there was any of that with George Floyd, and I wonder if any of that was used. George was actually represented by Lane Lindsay here in town. I think Gerald Acosta. He was represented by a number of individuals, and we asked Lane to come on the show today to talk about.
Mr. Floyd had criminal history. Unfortunately.
He was also
that's-
arrested by Gerald Goins.
Yeah.
Yeah, what
You hear about
kind
that?
of bad luck is that? You have like one of the worst road cops in Minneapolis, and you also tangle with one of the worst road cops in Harris County. Like,
But the notion becomes clearly
terrible.
that
Like-
no human
Right.
deserves to be killed at the hands of an officer
Of course not.
stepping on his neck for 9 minutes and 22 seconds, alleged for passing a fake $20 bill, right? I mean, so
It's also historic. It's historic because for since the beginning of time, the police have gotten away with murder. And that's why I think Derek Chauvin did this in broad daylight in the middle on Main Street, whatever street it was, knowing he was being videotaped, because he knew that he'd seen probably many times before police officers essentially murdering other black men, minorities, and getting away with it. And the reason they got away with it and got away with it here in Harris County for many years was because the district attorney's office protected the cops, make sure that the grand juries no-billed them. And that's how they got rid of these cases. So these cops weren't even charged. If Derek Chauvin had done this in Houston 20 years ago, I guarantee you he would have been no-billed.
it would not be a story, Rob.
Right,
Well,
that's
that's
important.
badge on him. And that's the disgrace.
What's important is that this verdict shows that now we know that there is a line that is drawn. Okay, the shootings may still be questionable. Jurors may hesitate. The guy that was shot in Dallas, Botham Jean, in his home, Dallas jury said that, you know, in that situation, no, we're not going to accept the officer's explanation, and we're going to convict you of murder. In this situation, you have a 9-minute long video with the officer kneeling on this man's neck and chest area, and the society has finally said, okay, you know what, this is a line, this is a bit too far. I knew that there was something special about this in terms of the progress in America whenever I was watching Fox News and Sean Hannity said, this is wrong.
Wait, you watch Fox News?
He did that particular day. He did that particular day, I trust.
Jamal, just be careful because, you know, most of what they say is not news.
Oh, I
coming
understand, but I want to know what everybody's saying because I want to hear all the
What does Sean Powers?
Whenever
So
I heard that, I knew that something was up.
we have 88 Sean Powers.
You're
on-
right. You're right, Jamal.
What are your thoughts, Sean? And Sean,
I'm
Sean,
not here speaking for my office because I don't actually have authority to speak for my office. I'm here just as another lawyer. I mean, I'll tell you the truth is this, and going back to some talk about the performance of the defense attorney, what I saw, and I didn't see a lot because I was working for a lot of it and wasn't able. What I was able to see, I thought that he did a fine job for what the hand he was dealt for. I mean, to be perfectly honest, you got a very, very impactful video. And then all of the other videos that may or may not have helped him, I don't think helped him enough to really have a great case from a defense attorney perspective. I think he made a lot of the good arguments that he needed to make. But at the end of the day, I think, you know, when you look at a jury pool, I mean, how are you going to find a jury pool that hasn't been impacted by this from before he was even charged? So, I mean, I think the defense did do the job that it needed to do. And I say that in admiration for the defense, not to in any way defend Chauvin's actions, but just from the admiration of defense bar in general when I deal with them. I understand the sentiments as far as past DAs protecting officers. I was not around 20 years ago.
I'm not blaming you for that, but it is a fact that the district attorney's office, up until recently, no-billed police officers in every single instance. And it's only recently that we've seen change.
Well, so it's very interesting that you kind of bring up that point, Rob. Did anybody happen to see the public posting that the Minneapolis Police Department put up the day of or the day after this incident? It was basically their little synopsis of what had happened.
Yeah,
Um,
they were covering. They called it. They said that Florida's having a medical condition and died from an apparent medical condition.
right. They didn't have, it was very, think of it like a short probable cause statement kind of thing. Hey, we were dispatched to forgery in progress. Um, we located the suspect. He resisted arrest. Uh, Officers noticed that he was appeared to be intoxicated. Um, he was thought to be having a medical emergency, was taken to the hospital after his arrest, and was later pronounced dead at the hospital. It was very different from obviously what we saw in the videos. And, without, if you go back 20 years, without the videos that were present in this case, you would have had 3 or 4 or 5, however many officers there were, that wrote reports that were very similar to what that little press release was on the Minneapolis Police Department website.
Wade, if there was no video,
Would have been no bills.
if there was no video of what happened, I guarantee you the police reports would have read just like you said, and there's a good chance Derek Chauvin would have walked if there was no video. Video is what
He wouldn't even have walked. He wouldn't have had to walk away from anything. He would have walked off
Probably
shift
wouldn't have
and
been
back
caught.
on to shift the next day.
I mean, cops lie in reports all the time. We know that. And, I mean, we see him, what was a couple of years ago where the cop shoots the man in the back and then comes back and puts a throw down next to him. I mean, that's the history. It still goes on. Anyway.
Can you talk about any of your experiences in intake? Do you ever get a phone call, or do y'all ever get a phone call from a police officer you just find so uncredible that you're dealing with someone who's not telling you the truth? Or all the police always tell the truth? Or I don't know. I'm asking this from a pure perspective of never having worked intake.
I'm not here to talk for my office or anything from that perspective. I'm not sure I'm authorized to do so. This kind of happened as a whim. I wasn't sure I'd be talking much at all. But what I will,
no problem.
Perfectly honestly, I think, and this is a more generalized statement, I think officers, just like prosecutors, and just like any profession, there's a spectrum of people that you're dealing with. No matter what that spectrum, what job you're dealing with, there is a spectrum of people with different viewpoints and different approaches to every job. I'm sure y'all, as defense attorneys, can acknowledge that defense bar has many different perspectives of all different strategies and different approaches to the job. What I will say is, I think that in that spectrum, there's a number of people that should be doing a better job to be focusing on the better, the more important motives behind what they're doing, and have a realization of what they're there to actually be doing, which is to protect and serve, and actually to make sure that our society as a whole is a more harmonious place. And I think that's the point that people, that sometimes officers lose sight of, is you're there to not to create aggression, really, is to create harmony in our society at the end of the day. You're there to make people of every race, creed, sex, sexual orientation, identity, whatever it is, should not matter one bit. You are there to make sure that everyone feels safe. Everybody can go forward with their days and not feel as though they need to look over their shoulder. They need to be watching that other person over there because they might be someone who might be dangerous to them, which includes themselves, like the officers themselves. We should all be focusing on trying to create an atmosphere that just creates a better society for everyone, regardless of who you are, and which helps the economy. It helps people's sense of safety. It helps really all of the issues of our society. If we can focus, if our people in authority focus on that idea, is your purpose there is to make everyone around you's life better. And I think, and I'm speaking in broad strokes here, but I think that mentality and that approach to policing, as well as prosecution, as well as really any job, honestly, but it's more, you have so much more contact with the general public in those positions that you have the more ability to do that. And I think that should be the focus, as opposed to a focus on militarization, as an us on an us versus them sort of a mentality of policing. I don't know if I don't know if that just sounded totally hippy dippy esoteric, or if I got my point across with all of that.
You did, and we've
did.
actually reached the halfway mark. It's 8:30. We have Wade. You have some things that you're working on.
Yeah. So
Yeah, we heard you had some fireworks in one of the courts in the last week.
well, yeah, you could call them fireworks. Maybe they haven't even. I think the fuse has been lit. I don't know that the fireworks have really happened just yet, but essentially, one of my we got hired on a case, and the client was required to appear in person for court last week, and one of my law partners, Clay Conrad, went to appear with our client in person since our client was ordered to be there in person. He was not permitted to go into the courtroom. This is in the 338th with Judge Ramona Franklin, which this organization is well aware of and deals with.
Who couldn't go in, the client or the lawyer? I don't know.
The lawyer. Clay was not, they called the client into the courtroom, and the bailiffs would not let Clay into the courtroom with our client.
Okay,
They were insisting that he would have to Zoom in, which he said that's.
that who would, the lawyer would have to Zoom in while his client's in the courtroom.
Correct.
All
Correct. And eventually what ended up happening was the coordinator said, okay, well, fine, you can appear, or the court actually, I guess, said, you can appear in person, come back next week. So next week was today. Clay goes with the client to court. That docket starts at 10:30. They were there. And Clay was not called into the courtroom until nearly 1:00. So the judge made him wait the entire docket. They called Clay into the courtroom, left the client in the hallway, and I wasn't there, so I don't know the entire exchange between Clay and the court, but Judge Franklin ordered Clay to file a brief explaining why she couldn't order a defendant into the courtroom without their lawyer. Essentially, is what that amounts to. And needless to say, Clay is pretty exasperated and upset by this. He's working on the brief now, and
Why don't you just suggest?
He's actually going to brief it?
No, this is
I'm
an abuse.
sorry, Rob, I didn't hear your question, but Justin, yes, he is actually going to brief it. There's
I've heard of judges asking for briefs on legal issues that pertain to a case, but not on just like,
Yeah.
why do you get to have an attorney in a courtroom? Or actually, attorney, why do you even want to be here?
right. And, HCCLA already has one judicial grievance pending against Judge Franklin for the bond issues that I know y'all have talked about on this show before. She now has another one.
Doesn't
Whoa, breaking news flash. You heard it here first.
Yeah.
So Clay filed a grievance against Judge Franklin for this?
This afternoon, yes.
like
Wow.
Let's get the nomenclature right, guys. They're with judges. They're called judicial misconduct complaints, and they go to the Commission on Judicial Conduct in Austin, and usually they deny them. But she's already got one filed, and apparently another one's been filed. And she's, it's interesting with a judge who has one pending complaint engaging in this kind of conduct. There's also a huge editorial that the Chronicle ran about her abusive policies, like locking the courtroom, not letting people in.
Well, that issue goes right along with this, because essentially whatever happened in the courtroom, Clay was the only one to see, because as David informed me, Judge Franklin does not live stream her Zoom proceedings. She's
in open violation of the Constitution, because the Bill of Rights says you have a right to open trials, open courts.
Wait,
It's not
wait,
simple.
continue a little
Lauren,
bit more on that point, Wade, because what you're saying is important. Because for anyone that represents people in Ramona Franklin's court, you have to log in through Zoom because you're not allowed in the courts. The stream, there is no live stream for that court, is my understanding. So you're not allowed to log into Zoom and see everyone. I believe you're placed in a waiting room, and then I believe people are let in. I don't know how many at a time.
One at a time.
Case by case.
And they're not letting anybody into the courtroom unless it's the person whose case they're dealing with. So
And we've had other complaints that you're represented, when she was letting attorneys in, if you're represented by 2 attorneys, only one was allowed in. What I would point out, Wade, for you to tell Clay, so he can amend his, if she, and he can put it in his brief to her, if she's gonna rely on the COVID restrictions at the courts, well, then it does require that she live stream. Okay, she must allow open access, and she is not doing that. So you've got to do it all. With all respect, Judge, you have to do both. You cannot simply decide, I'm not going to live stream. It's too many technical problems, but I'm only going to let one person in the courtroom at a time, and nobody else can witness what I'm doing in my star chamber.
correct. And I'll make sure to point that out to Clay, because that is the basis upon which she's relying on is COVID protocols and yada yada.
But,
And as a matter of fact, it's very
your partner also well knows the constitutional law that's being violated here. I mean, this is fundamental due process, and I don't think this judge is. I think she's disrespecting not just the individuals, but also the Constitution of the United States, the Bill of Rights, with this kind of conduct. And
At the very least, Sixth Amendment, right? I mean, at the very least,
Right.
right? I mean, at the very least, Sixth Amendment.
I got a
Right.
text message from another
Yeah.
judge who said it's sad. This is a clear Sixth Amendment violation. And
Right.
I couldn't agree more.
And the other judges, district court judges, we have some really good district court judges who are very respectful of constitutional rights. And so they're
Mhm.
embarrassed by this. It brings disrepute on the entire judiciary. And that's why it is important when a judge goes and does stuff like this to file judicial misconduct complaints. And HECLA, as David said, has already filed one. David's on the board, voted for it, I'm sure. And how long ago was that, David?
Oh, about 4 months ago.
Yeah, I mean, it's not even that long ago. And then y'all are experiencing this. I mean, it's just wrong, guys. That's why, as an organization, HECLA has to stand up to abusive judges. And it's, it takes some cojones, but it's necessary because nobody else will.
Yeah.
I mean, if nobody else, and the judges rarely file complaints against each other. They're supposed to, but they don't. They send text messages to Justin. Fairly safe.
well. I tell you what,
Better than nothing.
I
Yeah,
have never seen Clay so upset when he got back to the office today. He was very agitated about this, and rightfully so.
Well, I mean, the basic concept, I mean, everybody out there in TV land knows, seen on, you have a right to counsel. Well, it doesn't have any meaning if your lawyer's in a different place and separate it out. And using the COVID as an excuse, as I like what David pointed out, is, well, if you're going to use COVID as an excuse, then you have to adhere to all the rules.
Yeah,
It's-
that's a great
it's not,
point.
Cherry pick what you like and try to separate the client from his lawyer and make his lawyer stay out in the hallway so you can do whatever you want to. And and the lawyer can't even witness what's going on in there.
Do we
no, you
do
gotta
any
draw a line somewhere.
do we think that every energy trial case, at least typically, at least that I've been involved in, we filed a motion, we object to it. Do we think that anything in the future that these cases are coming back for any sort of issues that the defense bar has raised, or is it something that we are, preserving for the record and doing it? But do we have any teeth on it? Does anybody think that we're going to be successful on those objections that we've raised?
JV, I really think it's going to depend on the exact way and what specific objections were made in an individual case. But I do think that if done correctly, I do think that there's some potential for many of these if it was preserved. For some of these cases to end up back down in the courts after going through the appellate process. We had filed an objection to non-traditional trials in one of our cases, and it ultimately, because they were trying to force us to trial back in December, and ultimately the court and everybody relented and reset the case out to much later on down the line. I think now we're toward the end of this year or in the fall, because of the things that we cited in our motions and our objections to voir dire NRG.
What is it?
JB, you've tried cases there. I've tried cases there. We've picked juries together. It's patently unfair, period. There's no way, the way it's set up, regardless of what the judiciary tell us, that it's fair. You cannot traditionally build a tribe of humans that are supposed to get together and enjoy or disenjoy the case that they have to deal with. At NRG, they sit 8 feet apart and however deep back. It's impersonal. It's gross. Everybody doesn't want to be there. However, yet, regardless of the wisdom of those in Austin, whoever they are, or those that thought this was a great idea, we're still supposed to do this in the middle of a pandemic. When what 30% of our population has a vaccine? It's unfair. It's not cool.
I do not trust the Texas judiciary to do the right thing. I suspect, as we always say in criminal defense, there are two kinds of error, harmless and waived. And despite whatever objections we've made, I don't believe that they will carry the day in any Texas ultimate decider, meaning the Court of Criminal Appeals.
We're going to try
but
them,
there might
David.
be something worthwhile on federal writ.
We're going to try them, and we have tried them. The point is, it's not fair. Objectively, the situation is not fair.
Well, sometimes people need to say no rather than saying yes, crime. And
Isn't that the whole?
That's overruled, counsel. That's overruled, counsel.
You know what?
They set up NRG as a way to, because they were given a mandate to make trials happen in a way that are safe during a pandemic, to reduce the risk of exposure, right? But they didn't say, and also make sure that people can get a just outcome. So they followed the mandate.
Randy Martin from the Public Defender's Office. I don't mean to hijack the show, but today, he's an old buddy of mine.
Just go for it.
Today, he was on Zoom visiting with the court I was in. He's like, court was inquiring about his trial. He's like, Your Honor, I couldn't hear what was going on at NRG. And then when they brought it back to the courthouse after jury selection, he said, I couldn't hear really anything that was going on. And the jury couldn't hear, and they asked question after question per him, question after question after question. Now, he did say, anecdotally, hell, some of that might inure to my client's benefit. But the reality is, we're having trials where people can't literally hear what's going on. And honestly, that's fucked up, man. That's not cool.
God used the air.
You're absolutely right, Todd. And Rob and David and Todd, y'all have all hit on something that we've discussed at great length in our office. My other partner is Paul Looney, and Paul has talked about how if we get boiled down to just the facts, it gives the state a distinct advantage. We have to be able to appeal to humanity. And if we get boiled down to just the facts, which is what these NRG trials do with people wearing masks and being spread out and not being able to hear and not being able to express any sort of emotion or humanity, we lose that edge as defense lawyers.
All right, but look, here's the real talk. There is a notion that we have to attempt to get adjudications for humans, right? We can't have them linger in jail, right? I
Right.
get that. I have a lot of open cases. I get that. What's the right context? I think these judges are working in good faith. I'm telling you,
Not all.
as
some.
the practitioner, the way that it's set up in NRG is not fair for the defense. That's what I'm saying. I don't have
Well,
a
and I
COVID
think-
objection anymore.
I
I'm
don't,
telling you,
let me
it's not
interject one small
objectively
point
fair.
because if I think it's unfair for both sides because think about it.
Right.
If a jury can't hear, how's it fair for even the state? So it's not fair
Well-
for if people can't hear.
And the CCA just said the state has
Do in order
just
to
as much of a
evaluate
right to
evidence.
jury trial. Yeah, that's exactly right. And the CCA said the state just has just as much of a right to a jury trial. So if they can't hear us and we lose our edge, be careful, Wade, because Sean can hear you say that. If we lose our edge, so do they, right? They can't connect with people either. And the prosecutor in the George Floyd trial, he said this is not I just said it. Derek Chauvin trial. He said this is not George Floyd's trial, but he did everything he could with the witnesses that he caused and the exhibits that he entered to make that connection with the jury and be personable. So prosecutors need that too. I just, I think that it goes back to, it reminds me of the saying that I think sometimes it's attributed to Benjamin Franklin incorrectly, that those who would put safety over freedom deserve neither. Those who would put a safe trial over a just trial, neither one of those is going to be the outcome. Because I also don't know what the actual safety of the whole measure is.
You just can't have a fair trial in the middle of a pandemic. And trying
Right.
to force trials during a pandemic and
All right, but
and make lawyers go to trial during the middle of a pandemic when they can't see all the jurors, when they can't do the things Todd's been discussing. It's simply unfair. What's behind all of it is the historic way the judges look at themselves, which is they've always had a kind of a contest where they measure, many of them measure themselves against each other by the size of their docket. And historically, they have viewed themselves, whoever has the smaller docket is winning. And
all right, but
typically, whoever has a smaller docket is maybe the worst possible judge because they've coerced a lot of pleas. So the judges are worried about their docket. It makes sense they worry about the growth of their docket. But when you're in the middle of a pandemic, an international pandemic, you can't expect the trains to run on time. And that's what they're trying to do. That's what they tried to do at NRG. They spent millions upon millions of dollars for a handful of trials. It's absurd. And I'm sorry, I'm just not too interested in the state's rights. But every single defendant who's been put to trial has been put to trial in an unfair manner.
Todd, last word on this. And Jamal's
the judges that I know that are going to trial there want the defendant to have a fair trial.
Well, then they shouldn't be doing what they're doing.
They want them to have a trial.
Well, there's a dilemma because the dilemma is you have a jail packed full of people who are waiting on trial. So do they just wait, until we figure out what's going on, or do they get their day in court? So, I mean, it's a difficult situation all around because some people say, you know what, I don't care about the NRG issues. I want my day in court because I'm tired. My family doesn't have the money to bail me out of jail, and I'm rotting in county jail.
Well,
not what I'm accused of.
Well, to that point, if you look at the majority of the trials that have gone at NRG, I think a very high percentage of them have been people out on bond,
right?
People who are in custody.
So,
and I don't know the numbers on it. I know there's only been 50 some odd trials since last year. but I think the lion's share of those have been people on bond. So it's not an issue of people who are waiting in jail.
Well, deals are cut down there, though, Wade. I mean,
Yeah,
true.
I mean, I know that, but but we all know that the trials that are going are generally not the people.
Bro, when I'm set, I'm set. Like,
Hey, with that being said, Jamal, well, yeah, NRG sucks. It's not fair. I don't think it is, and I think on appeal, I think they're going to be fighting on that for a little bit. I tend to agree with David Michael Ryan that maybe not in Texas, but I think federally, I think something's going to come back. I do.
Well,
But
there's
we
not
have
too
to.
much federal trials here. I can tell you that. The federal judges are a lot more careful about this. And they also have multi-defendant cases, but I have not had one trial in federal court. I think there's been one trial held here, and that's it. The federal judges, I think they're showing more respect. And I think, Jamal, you make a good point, but it's coercive to keep a man locked up and say, okay, we're going to keep you locked up until you finally give in and agree to this half-assed trial where half your rights are going to be taken away, and that's your only chance of having a trial. That's just not right. That's coercing the defendant into giving in.
But Rob, they've done that even before Energy. I mean, the Kitty Diddler cases. Until your guy was willing to plead out, the judges and the prosecutors would always find a reason to reset. Even when the legislature said these are priority cases, they found reasons to get them reset. So the coercing of pleas by this is not unusual.
The coercing of pleas.
Shoot, I'll say I'm waiting for Miss Madam Og to just start dismissing a whole bunch of nonsense cases and stop wasting everybody's time.
she's not going to, JB, because she doesn't have to.
I don't think she is. Hey, okay, we have Jamal. Jamal's here. Justin, let's talk about him.
Okay. Well, we talked earlier about the George Floyd murder and Derek Chauvin trial and the wave of calls for police reform that started even before that. Jamal's the HCCLA chair of the Police Reform and Racial Justice Committee, and I think we hope that he has his finger on the pulse of all the police reform that's coming. So is there anything we can expect? Has there been any talk about that outside of Minneapolis? I know the Department of Justice just opened an investigation into Minneapolis Police Department. What about Houston Police Department?
Well, locally, there's been a change in police chief from Art Acevedo to Troy Finner. And there was a story released today where Troy Finner wants to go after violent crimes. He wants to fix the criminal justice system. And I guess his idea of fixing the criminal justice system is speaking to judges and I guess people in the DA's office. I don't know if that's a wise plan if you're trying to fix the system, but
Speaking to them about what?
Right?
Yeah.
yeah, he wants to target some of the stores where they claim gangs like to hang out. I've heard this before years ago.
Don't they do that already?
What they want to do is I guess increase the number of nuisance abatement suits the county attorney's office files against these
Great.
stores where where people come in and hang out.
Some of the times this is just another way of racial profiling. Also,
That's what I was thinking.
That's
Clearly.
what it sounds like to me.
Clearly.
And we don't need any more of that. Harris County has a long history of a racist criminal justice system. It's inherent in our criminal justice system. It's a racist system. And all you have to do is look in the holding tanks, right? I mean, we don't need more of that. We don't need a police chief who's going to go more down that road. I thought we were, no, we're never past that, but we don't need that.
Well, I think it appears that they're trying to strike a delicate balance in between all of the bad press that's coming out about violent crime going up and actually dealing with situations like George Floyd, where officers go too far and they're dealing with these histories of police brutality. And it seemed, back in September, there was a report that was released with about 150 suggestions from the community for the police to take on. And in my opinion, it seems that they're trying to use old ideas to fix old problems. And some of those ideas just haven't worked. I mean, they're trying to this idea of community policing. I'm like, well, from what I can tell, the issue isn't really with community policing. The issue is with some of these task forces that are being created. I think some of y'all may remember years ago when they had the CRU, the Crime Reduction Unit, these guys that were riding around stopping people, for little small crimes like jaywalking, riding a bike at night.
Cowboys.
Right. If they didn't have anything on them, then they let them go, but it was still a shakedown.
Yeah.
And so these task force still exist. I mean, now that I think they just call them tactical task force, and they do the exact same thing. Same tactics, different name.
Hey, 10 minutes, y'all.
Well, I wanted to inject one thing back to NRG. We were talking about judges making people go to trial,
Okay.
but also there are judges in this community, district court judges, who flat out have said, I'm not taking people to trial there. It's not fair over there, and I'm not making anybody go to trial there who doesn't want to. And I'm not going to trial there because they recognize it's inherently wrong. And we have a lot of judges here, good judges.
There's other judges that are saying, yes, I'm taking them there, and it's fair, Rob. So, okay.
Well, I disagree. I don't think it's fair to make somebody go to trial there. It's inherently
Some
unfair.
think it's perfectly fair.
Has
They
has
think
the
they're wrong. Thinking something doesn't make it right.
the PD's office has not gone to trial there? Is that right, or is that?
Say again?
Also, I believe Randy Martin went to trial last week.
Pardon me. Wow. And wow, that's amazing. What were his thoughts? Is there any? Because he was forced to? I assume he made his objections and such.
Right. He made his objections, and if you speak with him about it, I believe Randy will say that it is not an experience he wants to repeat.
I mean, it's not.
My only point was that there were a lot of judges. And Todd, I understand that some of the judges you've dealt with may be well-intentioned. I don't know their heart. I just know that there are judges, district court judges, who flat out told me, I'm not going to trial there. I'm not going to participate in the NRG circus because it's not constitutional. It's devoid of due process, and they're not going to do it. And those judges, I think, have set the right standard. And it's not to keep people locked up. It's to make sure that we preserve the due process that we fought so long for. Anyway, and I know some lawyers, there's at least one on the show who said he would not go there. I said I'd go to jail with him, but we're not eager to go. We've managed to stay out of jail this long. So
do we
But
think
you balance that, Rob, with getting humans in a trial as quick as they can, man.
Let me ask you.
How do you balance that? That
Do
becomes
you think Zoom is here to stay? Final thoughts. We have like 3 minutes. Final stop. Do we think Zoom's here to stay? Courts and trials, or
I hope so. I wouldn't it be nice if we could just make our disposition settings by Zoom rather than having to go down and fight the crowds at the courthouse? They pressure people into pleas by making them come down for all these settings, and that's historic. If we could reduce some of that pressure by not making people go to the courthouse and have fewer settings, then it would be a more fair system and a more just system and less coercive. I would favor that. I don't know about y'all.
what do y'all think?
Well, I think we're going to end up with a mixed bag. I would, as we all know, most judges, 32 different courts in Harris County. It's kind of 32 different ways of doing things. And that's just Harris County. And some of us practice, in other counties as well. So I think we're going to end up with a mixed bag of judges who will keep Zoom around, others who will dispose of it as quickly as they possibly can because they hate the notion of it.
Jamal, what are your thoughts?
I think it's going to be around in the future. I agree with Wade that it will be a mixed bag. I think some courts will rely on Zoom for people to have quick check-ins if there's an issue. However, I don't expect Zoom to be used for any sort of adversarial hearing.
David Michael Ryan, what about you? What do you think?
I disagree with Jamal. I think some of these judges are going to try and force adverse motions to revoke, motions to suppress, things of that nature to be done by Zoom, and that our rights of confrontation are going to be infringed by that. So I think a version of it's going to keep around, and in some courts, we're really going to hate it.
Sean Powers, what about you down in intake and such? What Zoom sticking around or what?
You're on.
You're muted.
We're not using Zoom at intake. I think that Zoom is like any other tool. It has its places, it has its uses. And I think a number of people have commented on where they think it's appropriate. I agree that it's appropriate in certain settings and others. I did want to take 1 minute that just to plug something real quick. That I am riding in the MS 150 this year. If anybody wants to venture to give a donation to fight a very terrible disease, go to the MS 150 page, look up my name. You can give a donation, and it helps out a lot. Thank you.
Justin Harris,
Thank
what do
you.
you think?
I'm not riding the MS 150. My bike would make it. I would totally be down, but my bike is the problem. No, I think Zoom is good in some ways. I just think that sometimes you've got some judges, like we've talked about, who just, you can spend 4 hours waiting to just be let into the Zoom. And I'm not exaggerating by 4 hours. You know, I have to have sometimes 2 or 3 devices going at once because I'm like, and then I tell the other ones, I don't know when I'm going to get let into this other court. So I may have to go real quickly. So, I can spend my whole morning on 2 courts, and I don't like that.
And
Todd, what are your thoughts? And send us out.
Making a lawyer wait 4 hours to Zoom in is punitive, especially in the circumstances that Wade described. And it's just wrong. I think Zoom could be used properly, but I've tried to cross-examine people on Zoom. You can't do it. You can't
do
see their
that.
body reactions. And I've been in situations where I've had to do a couple of hearings like that. It's not fair. You can't have an adversarial proceeding by Zoom. And making a lawyer wait 4 hours in the situation that Wade described, that's just punitive, and that's not fair.
Rob,
What do you think, Todd? Send us out. Tell us what you think and send us out.
my thoughts is hopefully Zoom is here to stay. I would tell all lawyers that have multiple settings, get multiple devices, just handle it up. Some courts take hours. Some courts you can get in and get out in a second, like for real. Zoom hopefully is here to stay with regards to not making humans drive down to court just to say hi when the court can see them on a Zoom while discovery is pending. I think it's a really cool thing that's happened. I hope the judiciary is serious about that, because as long as they see them, this person has not jumped bail or they're not going anywhere, the lawyers are working through the case. At the end of the day, I like federal court. We should have discovery orders where people should come to court, show up, say hi, and announce whether they want a jury trial or not.
Harris County Criminal Lawyers Association, HCLA, thank you so very much. Past presidents Todd DuPont and past president Rob Fickman, Wade,
He's the boss.
Sean, David Michael, Rob, Justin, Mark at the studio. Thank you so much. It's been awesome.
Have a good night. Good job.
Good job, y'all.